All right, good evening, everybody. Today is August the 7th, 2025. This is Tad with YouHaveTheRight.com, and we have Chris Hauser here tonight. And Chris is going to talk to us about his experience with using a UCC-1 financing statement as a payoff for foreclosure in judicial states and perhaps even other situations. So, hey, Chris, welcome back. It's been a while. Glad to have you.
Yeah, man. Yeah, it has been quite a while.
Yeah, it has.
Yeah, what we'll get into tonight here, first off, let me start by saying there's a lot of YouTube channels up that are claiming to be me.
Darn.
And there's only one that is actually me, and that's a Christopher Hauser, and I'm wearing, it's a picture of me in Desert Storm. I'm wearing desert BDUs and a desert boonie hat and a brown dust scarf around my neck. That's the only YouTube channel that I have. The other one was taken down, and like all the lives were gone, you know, because I didn't know how to record those. And I was recording the videos and putting them on a disc. Somebody made a disc for me when I first started getting into this, really, and sent it to me. And I was just adding to it. But I didn't know how to do the lives, so those were all lost. I've subscribed to all the scammers. One of them is the Grant scammer. Possibly two. Maybe he has two of them.
Wow.
But one of them, Tad, has got 109,000 subscribers.
Oh, my God.
People are still showing up at my house. Almost on 2 or 3 times a month, I'm getting visitors. And, yeah, my wife still gets pissed off about it. But, you know, what can I do, man? I don't have a channel anymore. Not doing any of this stuff. And yeah, so that's where that's at. If you go on the YouTube and you search Christopher Hauser, there's only one on there. There's one guy that's got my granddad's old picture and an American flag instead of the civil flag like I had. Another guy has got my face from my old Facebook account, and he's using that. One guy's actually, I don't know how he's done it, if he's, how he's gone about it, but he's actually gotten pictures from my new Facebook account. And he's putting that up, shit from family things that I've done. I've reported these. YouTube's not going to do anything about it. They never do. They haven't yet. But I subscribe to them just so when they post a new video, I can go on there and say, this isn't the real Christopher Hauser. Christopher Hauser's YouTube channel. This is a scammer. Don't give anybody any money, that kind of thing.
Right.
So, but what it has, losing all that and disconnecting as I have, has had its advantages also. I've had a lot more time to do other things. And right now, guys, this is what I'm doing now is crazy important. The banking, the private banking thing was a bust, and I got threatened to be sent on the it's called the night train. That's where the feds catch you up and they move you around so your family don't even know where you're at. I got away from that. But look, man, what we'll talk about tonight is what to do, what you can do. The Tennessee Supreme Court decision made a few rulings, and we're back in post-conviction appeals right now, and that's really crazy the way that's unfolding. I'll talk about it briefly, but in the Supreme Court ruling, they said a couple things. One, they determined that if you enter false information into books or records, that's forgery. They defined that section of the forgery code. And the other thing they said was the UCC-1 has value. And before the court decision, the UCC-1 was a financing statement, and it was just a notice of a debt. John Q. Public owes me $100,000. Now, because of they had the option to rule that it was a forgery, but there wasn't a dollar amount, and which would have made it a Class E felony forgery. But because they determined that that they were forgeries and they were over $250,000, it kept us at a Class felony, which is 20 years. See, they couldn't. It was over 2 years. It's almost 4 years by the time they had the Supreme Court decision. So they couldn't say they had to do it that way, or they would be like, "We've kept these guys twice as long as we could have or should have. Now we got to pay." So they determined. They said instead of doing that, and if you guys remember watching the Supreme Court decision, Emma Tennant in her closing argument said to accept this UCC-1 as anything more than what it is, and it's a notice of a debt, would wreak havoc, or would create havoc, or however she put it, in the UCC. And what she meant by that is, if you say these things are worth something when they're not, that's going to create a problem in the UCC. Well, they decided not to listen to her, apparently. And they said, we'll call these things, and we'll say, yeah, these guys did this, and it's a forgery, and the UCC-1 has value now. And I emphasize the word now, okay? Because they didn't have any value before, but now they have it. And so what does that mean? That means a UCC-1 can now be converted into a negotiable instrument. Sounds good, don't it? UCC-1s now have whatever value you place in the collateral description. In Tennessee, item 12, and other ones I've seen in other states, it's usually 4. Item 4 on the UCC-1, where it gives a collateral description. Well, that tells you how much the individual owes, or how much the debtor is claiming that's owed to them. So what does that mean? Now, to make this as simple as possible, I'm a finance. I have my own finance company, and you come to me and, hey man, can I borrow $50,000? There's a new car I want to buy. Right? Because small institutions, especially small institutions, file these UCC-1s. And it doesn't. You're probably not going to have a mortgage company that files a UCC-1 because the mortgage company isn't the original lender. The original lender would have the UCC-1 if they filed it all. A lot of times they don't do that on a mortgage. But back to the dealership or the finance company, say I own a buy here, die here car lot. You come into my car lot and you say, hey man, I want to buy that, that $24,000 car you got out there. Okay. We're gonna set up payment plans. You come in and pay me. Well, what they used to do was you would come in and pay them. And if you didn't pay them, they'd come collect the car. They would repo the car. What they would do is they'd file a UCC-1 on it. Right? That way they had first dibs on the car if it wasn't paid. So that's what they used to do. And then when you paid it off, it was good. The UCC-1's only good for 5 years. But you can renew it. In 5 years, you can renew the UCC-1. So that's the way it used to go. And that's the way it's still going now in most cases. But I'm the dealership. You can now, as a small financial institution, you come in and buy the car. I want to buy that car. It's $24,000. Okay. Here's what we're going to do. You're going to sign this contract declaring that you owe me $24,000. I'm going to file a UCC-1 on it, right? And then I can monetize that UCC-1 like we were doing. This is what we did when we sent them to the Treasury with the contracts of the Treasury from the conditional acceptance we were doing. That's what we did. We monetized the back of it. But now we have a Supreme Court ruling that says it's cool for you to do that. Because now they're worth something. So then what I would do is I would take it to the closest Federal Reserve Bank and go to the pay window. Chad, you did a search on it, was a credit something or another window?
Let me see here. Chat GPT.
Yeah.
I gotta find this little search thing.
It doesn't matter, but if you guys do an AI search or search in general, you'll find out that it used to be called a pay window, but apparently, according to Tad's chat with GPT, it's called the credit something or another window. But anyway, each Federal Reserve Bank has a pay window, more or less, that you can take negotiable instruments to and get paid. So back to the scenario where you sign a contract with me.
There we go.
And I do the UCC-1, and then you keep making the payments to me. Well, the original loan was for $24,000. Say you pay 3 years on it, you only owe me 8 or 6, right? I'm still holding a UCC-1 that's worth $24,000. That's where it can benefit the financial institutions if they get their heads wrapped around this pretty quick. I talked to a guy at a dealership, and I broke it down for him. Look, man, here's the case, right? When you do a UCC-1, if you footnote our case on that UCC-1, whoever you're taking it to, you can now go, look, according to the Supreme Court of Tennessee, this thing is worth what it says it is worth in the collateral description. So far, I've coached 7 people. I'm coaching more than that, but I've coached 7 people that have got their titles back on their mortgages. I've only been messing with the UCC-1s through the foreclosure. and they're getting their title, and the debt's gone. That tells me that, and here's what I've done. I did this myself with my dad's estate, and because it went into foreclosure. When he passed away in 2013, my brother quitclaim deeded it over to a lady who was a friend of my dad's. She had a doctorate in education, put herself through school, 2 kids, no child support. My dad helped her out with her college, and then she got a doctorate. She was a big principal of some huge rich school up there in Chicago. So, but she finally moved and she got a better job in Arizona, and she left and she quit making the payments. So they went to foreclose. And my siblings, because it was my dad's estate who was the original debtor, the heirs, me and my 3 siblings, are listed on this foreclosure thing. So I called my older brother and said, "Hey man, what's going on with this?" He's like, "Oh man, don't worry about it. They're foreclosing on the house. Just sign those papers and send them back to the lawyer, and you won't be held liable for any of this debt." Well, my siblings did that. I didn't. And because I told him, I told my older brother Jeff, I said, "Look, man, we can fight this. The debt's already been paid. It was paid when Dad signed." "Oh, that's the shit that got you put in prison." Right? My siblings pretty much disowned me. Or, yeah, well, fuck it. It's their loss, not mine. But I made it pretty rough on them, and I'll get to that as soon as I finish this. But the first time I went into video conference with this chancellery court in Will County, Illinois, I said, I asked him, I said, "What jurisdiction are you operating under?" He said, "Well, what do you mean?" I said, "Well, every court, you're a court, right? Has to be operating under some kind of jurisdiction. What jurisdiction are you operating under?" He said, "Well, Will County, right?" I said, "Okay, cool." I said, "The other question that I have is, who authorized you to get my Social Security Cesticate trust number and access my account to determine whether or not I was in the military?" Because apparently everybody who's goes into foreclosure, they take your Social Security number and to find out whether or not you're in the service. Because if you're in the service, apparently you can't be foreclosed on. They got to wait till you get out. So, yeah, you can actually buy a house as an E2 private and do 20 years in the military and never pay a dime and not get evicted. But because it's foreclosure, I'm a veteran or military. You're actually a government issue. You belong to the government. So the government really can't sue you because you belong to them. You're their property. But anyway, I knew that they did this because they had the last 4 of mine and my siblings' Social Security numbers, and this lady that would quitclaim deeded the house over to. Now, this house is $527,000. Really nice neighborhood, all brick. The fireplace, the double-sided fireplace, was almost $20,000.
Wow.
So I said, "Okay, cool." I said, and as soon as they said that he's like, "Well, I don't know, man. That's just what they do." Right? And I'm like, "Who's they?" You know what I mean? Because I want to know who authorized you to act as a trustee. Right? Well, that's just what they do. Okay, so now you've agreed that you're a trustee. I said, how is you stealing my inheritance acting in a fiduciary obligation? And at that point, dude was like, we're going to have to reschedule this for another date. I said, okay, fine. I said, but before you do this, before you schedule another date, you need to inform me at least 2 weeks before it happens. Not like this time where I got paperwork and the day before. I said, you better give me plenty of notice when this next hearing will be, because I will be in it. So we hung up. The first thing I did, y'all, is I went to Dun and Bradstreet, and I pulled Will County's DUNS number. And the next time I went in, I said, this is your DUNS number. You're acting as a corporate entity in a commercial transaction. And you're also acting as a fiduciary in my trust, along with my siblings' trust, even though they wrote their inheritance off. I said, so what is it you're going to do that's going to benefit the beneficiary? And he's like, well, I don't know anything about that, but this is what my job, and, blah, 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 blah. I said, look, man, I said, here's your DUNS number. You're a corporation. I haven't contracted with you at all. Why are you trying to steal my inheritance, man? I said, don't you know the Bible talks about leaving an inheritance even unto your grandchildren? I said, you guys are backing up real bad. I said, but hey, I said, how about we'll settle this? I'll settle this debt in full. He's like, well, yeah, you can do that. Just contact this mortgage company and send them a payment. I said, no, I'm going to do this right here, right now. That way you can have this on your record. I said, the Tennessee Supreme Court, actually, at first I asked the mortgage company guy, the counsel for the mortgage company, I said, did your mortgage company file a UCC-1 on this debt? He said, no, we don't do that. I said, yeah, I figured you probably did, and that's why I asked. I said, but the original lender probably did. He said, well, I wouldn't know that. All right. I said, okay, let me explain something to y'all. I said, did you know that a UCC-1 now has an ascertainable value and can be monetized? And the judge was like, I ain't never heard of nothing like that. And, the lawyer's the same way. I said, let me read to you from this case. And it was like Tennessee Supreme Court, M219 dash 5 numbers and dash CS dash R3 dash CD or something like that. I read the case number off to him. Well, I said, let me read to you what the Tennessee Supreme Court has ruled. And I started reading it. Before I got halfway through it, the judge had it also pulled up on his computer on his desk, and he was reading right along with me. I said, even though my dad created the negotiable instrument when he signed the contract and the bank monetized it and got paid, I said, I'm willing to settle this right here, right now. I said, I said, first of all, the mortgage company didn't loan my dad any money, did you? Well, no. I said, yeah, because the original lender loaned the money, right? I said, so how is it that his heirs owe you money when you didn't loan him any money, which means you didn't loan us any money, right? And he started like that. I said, look, man, all you need to do is file a UCC-1. And I said, you can do this you can stop frigging around and coming up in here and wasting everybody's time. Because this mortgage company, if they claim there's a debt that someone owes them, all they need to do is go file a UCC-1, print it off, because you can do it in 20 minutes, over the internet, and they'll send you an email with the UCC-1 on it. Flip the freaking thing over and monetize it and go to the pay window. It's that simple, man. And this judge is like, this is fascinating. So yeah, they've actually declared, because I said that's my case, by the way. They've actually declared that the UCC-1 has value. So, and he said we're gonna defer this hearing and give me. He said so I can have a little more time, or we can have a little more time to investigate this Supreme Court ruling. All right. I said, well, take all the time you need, but give me my estate that's heired to me. Right? I said, because I'm not going to play this game for 10 years like I've seen you guys do this. 3 weeks later, I got a note from the court saying that the mortgage company did a reverse foreclosure. I don't know if y'all are familiar with that, but they did a reverse foreclosure. 1 week later, I got the title of my dad's house.
Yay.
And it's on the market right now. So
double yay.
Yeah. I'm selling it, and then what I'm going to do, because Scripture taught me that a man should leave an inheritance even unto his grandchildren. So I've got nieces and nephews. My older brother's got 6. My younger brother's got 1. My sister's got 4. I've got 5 of my own. So what I'm going to do is I'm going to sell the house, and I'm going to divide the money up between all the grandchildren. And that way, this is how my siblings eat crow. You know what I mean? I mean, there's 6, 10. Each one of them should get $30,000 or $40,000.
Wow.
And my siblings aren't going to see a freaking dime. They're going to see a dime of it. And that's what they chose. So that's what a UCC-1 will do. Now, I've coached a bunch of people. I'm still coaching people, and I'm not charging anything because I don't do it. I'm doing this because people need to take advantage of it while they can, because it might not always be that way.
Right.
If you're doing it, you need to do it quickly. I've talked with dozens of people, and maybe 1 in 9 is actually willing to go this route.
Yeah, right.
Everybody else is scared. You know what I mean? Oh, well, I don't want to go to prison. You're not going to go to prison because it's a civil suit. You can't go to prison for a debt in a civil matter. So you can't be in prison for a debt in a civil matter. So, and that's what a foreclosure is. It's a civil matter. You're not filing the UCC-1. The lenders are. So why not take advantage of it? Some people are, man. 7 people so far have got their titles to their homes and had their foreclosures thrown out. The other people that I'm working on haven't got into it deep enough to go, because you're going to go 2 or 3 times before they go, okay, I see where this can work. You have to know what you're talking about when you go in there. You got to know. Don't go in there freaking dumbfounded and shit because you're going to lose your ass. That's the way it's going to work. You can't go in there not knowing what you're talking about. You know, that's how it helped me. That's why I coach folks, because I want them to be successful at it. Because the more people that do this, the better the odds are of this working. Once it becomes commonplace, the banks are going to be going to the people that are ignorant of it. They're going to be going, hey man, we don't need to. We noticed you're a couple of months behind. We don't need to go to foreclosure with this. Here's how we can settle it right now. And they're going to do it for you.
So, Chris, what I'd like to do is to put together kind of a detailed process, make it a kind of a course, inexpensive course at the website.
Yeah.
See if we can get people that are serious about it, and maybe have like weekly trainings or something like that. And, just have people go through how to fill it out, how to talk to the judge, and all that other stuff. Contingencies, what to do when things come up. To try to make it as clearly laid out as possible. Because I know that you work with a lot of people, and you can be so easily overwhelmed. And I'd like.
Yeah, it is. It has been.
Yeah.
But I've had time for it because I'm not freaking dealing with a bunch of emails and, like I was doing before and answering a bunch of... The channel that I got up now, it's like, I don't know, there might be 200 or 300 people on it, So I don't get a lot of messages, and I don't post a lot.
Right.
I used to post a lot. Now I don't post a lot.
Okay.
I just do whatever's... whatever's on my mind. Most of it is our case, what's going on with our case right now. And that's what happened with the case is Tennessee ruled, the Supreme Court ruled in favor of Blackburn's court. Which means they didn't budge all the way through the Tennessee Supreme Court. And that's the benefit so far. But what happens when it goes to the end of the state, when it goes to the end, when the appeals run out, okay, then it goes back, the case goes back to the original court. Ron submitted the motion to dismiss to the Tennessee Supreme Court, but they didn't get it till the case was already remanded back to the original court. So they didn't even deal with it. They sent it back and said, we don't have a case to put this in here. It's back in the original court. So by him,
we got quite a few people on here, and we're going to have some questions. Are you available for questions right now?
Well, let me finish what
right.
I'm talking about.
Sure.
So it went back to the original court. Now, once it does that, you can file for post-conviction relief. You have 365 days from the day the Supreme Court rules, right, which was the 15th of May of 23. So we had till the 15th of May of 24. So we got it together. Ron got out. We worked on it together, and we submitted it. And we sent 3 copies of the post-conviction. We sent them out on the 9th of May of last year. By the 10th, they were in Nashville. On the 13th, Scrimetti, who is the Attorney General, got his copy. On the 14th, the judge got her copy. And then it was probably the 15th, which was the last day, to have it in. The clerk got it. Now, when you look at the green card, instead of 5/15/24, it says 5/16/24, and the 16 is darker, like they went over it a couple times. They actually changed. If you look at it close enough, you'll see that they changed 5. They started to do a 5, and they changed it to a 6. Well, now the judge had 30 days from the 15th of May to make her decision on the motion. Well, she waited till April of the next year. Almost 10 months she waited. And then when she looked at it, she said that we had a colorable claim, and yes, this is these are good grounds for post-conviction relief. She said, but we're not looking at it because it was a day late. She was 10 months late, right, in doing what she was supposed to do. She had a stroke a few years back. Her last day was the 31st of May. She actually got released, had let a dude release the dude that beat his girlfriend in Nashville, and he went back to Mississippi and killed her.
Ooh.
So all the lawyers were screaming, she's incompetent, she was falling asleep in murder trials, falling asleep on the bench. And so these lawyers were trying to get her removed. So she resigns instead. And yeah, if you look up Cheryl Blackburn, Judge Cheryl Blackburn in Nashville News, you'll see what the whole story with this guy that killed his girlfriend. And they even admitted it. She even admitted she was wrong. He didn't do the release instructions. So instead of the guy having to stay in Davidson County, he left. And instead of having an ankle monitor on, they never put one on. He ended up killing his girlfriend. Her dad was he's an orthopedic surgeon in Mississippi. I actually talked to him with him for about 45 minutes.
Wow.
A few months back. And so it goes to post-conviction. She says that, I reviewed this after 10 months, and I find that these guys it's not due process. It's not a due process issue because of the statute of limitations. So it's rejected. Well, we appealed it, or I did, appealed that decision, so now it's in the appellate court. Well, when I did the original appeal, the first appeal, Blackburn sent her response to the court, to the appeals court, saying, Hauser's filed this in our court, and he was the only one that signed the affidavit, the affidavit of truth. But I filed it Christopher-Allen Hauser, comma, beneficiary and sovereign, et al., which means everybody. And the reason I said et al. Is because you can't be severed. You and your alleged defendants, co-defendants, pre-trial you can ask for severance. All the way through the trial you can ask for severance, and the judge can grant it. But the defense has to ask for it, or the prosecution has to ask for it. The judge can't sever. One of the two sides has to request it, and then the judge decides whether or not this is doable. Now, if they would have severed us before the trial, and there was 24 witnesses, 12 of them were mine, probably half of those would have also been every other one of the 5. So these people would have had to come back to 5 different trials if they severed us like that. They kept us all together for convenience. And what ended up happening was you can't sever. So Blackburn is saying that she basically severed us in the post-conviction relief, and she can't do that. And she was saying, well, Hauser's the only one that signed the affidavit of truth, but she sent the case up, and now the appeals case is Lyons, Hauser, and Usinger. It's not Christopher Allen Hauser at all. So we actually have a case that's in appeals right now where not all of us are appealing. And the judge also said in the letter to the appeals court that even though it's just us three, and see Austin Gary Cooper, he's at all too, right? The case that they sent up to the appeals court is the case that we were all involved in. And then there was Gary, because Gary was there under two different cases. He was convicted under two different cases. But they ran them both together in the same trial. So what they did when they sent that up, they sent both cases up. And the other case that's in there now is Austin Gary Cooper and Victor Bunch. Victor copped a plea. If you're saying that it's only us three going into the appeals court, why are you sending a case up that has somebody that you're claiming is never in it, was never in that? Why are you sending this second case up to the appeals? Because we're not severed. They're trying to push it out that way, but it's not going to work. So I did what's called whenever you go into the appeals, you have to do a brief and submit a brief. And the one I submitted was 18 pages. And it just had 5 topics on it. Well, I sent that up, and they sent me a thing back saying that they were going to charge me $550. And I called them. I said, "Why are you charging me? All through the trial, you had us all indigent." She's like, "Well, I don't know nothing about that, but you can always file an indigency again." So I took the standard form for indigency, and I changed the word indigent to impecunious, and I filed it. Well, in there it says, on item 8, it says, if you have anything extra you want to add or any questions you might have, this is what the space is for, Section 8. And I put Tennessee Constitution, Article 117, where it says the court should be open without sale, denial, or delay. So you're not even supposed to be charging anybody anyway. So I send that up, and the court rejects that. Well, right after we sent that up, we filed a motion for judicial determination. It's a damn, that's not what it is. Take judicial notice. A motion to take judicial notice. Well, the reason we did that was we wanted them to notice some things, and when you file those, they have to address it. Anytime you move the court with a document, a motion or whatever, they have to address that before they can move on. Right now, they're stuck at. When they sent me the denial, the second denial for to proceed as a pauper is what they call it. It said in there that I was denied, and then in that same, they sent us a letter that had 2 paragraphs in it. One was they accepted our our demand to take or our motion to take judicial notice, and the second paragraph was about being pauper, proceeding as a pauper, and they refused to do that. So, or they rejected that, the one that I sent in. But it said in the same paragraph that when they reject it, they have to give you the reasons, with an S, in writing. Well, they never did that. So we did a motion for clarification, right? Clarify why it is that you're refusing for me to proceed as a pauper when you're not even obeying your own rules that say you have to tell me the reasons in writing. Where are the reasons? So right now, the court is stuck. They have accepted our motion to take judicial notice, and there's 10 points in there. One is put the Tennessee Constitution in the case. The other one is put the United States Constitution in the case. Another one is look in the transcripts where the court is hiding exculpatory evidence from the jury. In the trial, they had our conditional acceptances. They had our contracts in the record, and they talked about it on the record. It's in the transcripts. So there's a conspiracy to hide exculpatory evidence because the defense, the prosecution, and the judge were all involved in this conversation, and the defense attorneys didn't object. That makes them part of the conspiracy. So they accepted that. The appeals court accepted that. They also accepted, get this, man, they accepted that we're sovereign. They accepted that a sovereign can't be sued in court, because that's all in the take judicial notice. They've accepted all that. They even told us in this letter that, okay, we accept your motion to take judicial notice, but you can't talk about this in the oral arguments because it's not in the brief. So I got a hold of Ron and I said, "Hey, Ron, did you see this latest thing?" He said, "No, I didn't get it yet." I took some screenshots, sent it to him. He read it, called me back. I said, "You know what they're wanting us to do, don't you?" He said, "Well, what's that?" I said, "They're wanting us to amend the someone's coming up early. Actually, 2-3 people's coming up early. They want us to amend our argument. So we did that. So now we can talk about it in the oral arguments. And see, here's the thing, y'all. When we're arguing in the appeals court, we only should have been arguing why we believe that we were on time. And Blackburn even said in her letter to the appeals court that Lee Cromwell did file in time, but she hadn't had a chance to look at his post-conviction relief filing. So she's 10 months late on that one, too. Yeah, she knew she was going to retire, so I'm not even reading that shit. So what we did in the judicial notice was we said that because judge allowed that Lee Cromwell's was on time, ours should have been considered, even if it was a day late. It should have been considered an amendment to the Cromwell's, right? Because we're all together. Where one goes, everybody goes. All for one and one for all. So that's where we've got the appeals court stuck right now. Now, here's the thing. If you guys remember the videos, there was an attorney, an assistant district attorney, that was arguing for the state. And now there's a female. Her name's Elizabeth Evans or something like that. She sent her brief to our argument. And she said in her brief that Cooper and Cromwell hadn't filed a post-conviction relief when the judge put in the letter that Cooper did. This is just recently what came up. So we were working on this. We're working this into our brief and our amended brief. And I told Ron, I said, you know what this means, don't you, Ron? He said, well, it means that you know, she's wrong because we can use the judge's own written record that Cromwell did file, and she's saying he didn't. They're trying to say that it shouldn't be an amendment because Cromwell didn't file when the judge said he did. So Ron was like, "Yeah, man, this got him screwed." I said, "Yeah, this woman didn't even read what the judge. She didn't even read the record. If she'd have read the record, she'd have read that the judge said Cromwell filed a freaking a post-conviction relief, but she hadn't addressed it yet. So one of the two is lying. Either the judge is lying to the appeals court or the prosecutor's lying to the appeals court. Can't have it both ways." So I told Ron, I said, "Yeah, Ron, yeah, that's true, but even more. What did this Attorney General just do? She entered false information in the books of records. She just committed felony fraud, forgery. According to the state of Tennessee versus Ronald James Lyons, James Michael Usinger, Christopher Hauser, all that, blah, 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 blah." He's like, "That's right, man." I said, "Add that in there, too. Add it in there that we want her charged with forgery." This assistant district attorney that's supposed to be arguing for the state, she just entered false information in the books of records. That's forgery, man. That's forgery. So, yeah, he was laughing. I said, well, not only that, Jonathan Skermetti, who is the Attorney General for the state of Tennessee, she works for him, right? She works for Skermetti. She's an agent for Skermetti. What does that mean? That means Skermetti's guilty. That means Skermetti can be charged with forgery. The Attorney General of the state. So that's where we're at with our case, y'all. And it's looking pretty good.
Good work.
Looking pretty good. Yeah, I'm hoping that we get to argue this soon. Somebody needs to pay, man.
So are you ready to take questions?
Yeah, we can.
All right. We got somebody on a restricted line. When your phone unmutes, it's your turn to talk. And for those of you that are waiting, hit *6 on your phone, *6, and I believe pound to raise your hand.
It's been a little while, ain't it, Dan?
Yeah.
Okay. Hi. Hi,
Yeah.
Chris and Pat. Thank
Hi there.
you for your this evening. This is Lori. Chris, I have a question for you. My house is in foreclosure. It is set to be. The sale isn't set yet, but it's coming up August 6th when they're going to set a date. How quickly can this process be done?
What? Okay.
And then
Are you finished with the... Okay. Let's address that. How quickly can it be done? In the hearing. Go to the hearing and say, look, I'm ready to settle this right here, right now, today.
Okay.
All you need to know, okay, is our case. Look up our case number, and it says in the case that a UCC-1 has a value. It has value now. If it has value, it can be monetized.
Okay, so you've coached other people. I need some coaching, and I'd like to get in line for that. Can you help me with that? And I also have there's more to it, which I don't want to get into now because I don't want to. I know there are other people in line to ask questions.
That's fine. Why don't you contact me at the website youhavetheright.com?
Yeah, look, guys, this is really simple. I know it seems complicated because everybody thinks these lawyers are freaking, this is the court, these are lawyers, and, this is stuff you got to be smart for. It's not. It's simple, man. It's simple. A UCC-1 has value. Why not use it to get your trustees to discharge any debt they claim?
Okay. Can this be done if a mortgage is after a mortgage is reinstated?
Any debt that you have can be settled with a UCC-1.
Okay.
Any debt. It doesn't just have to be a mortgage. Any debt that you have can be settled with the UCC-1.
Okay. All right. Thank you.
I don't know how much that's helped, but that's what I'm saying, guys. It's simple, man. It's simple.
Well, I realize you're going to set up a course and have weekly training, but I'm on a schedule right now where I need to do
that.
Yeah.
I get that.
Yeah.
Let's see if we can talk tomorrow, see what we can work out to help you out, because I have trained a couple other people before. I had a whole bunch of people respond. Only one of them did it, but it sounds like you're motivated, so let's go ahead and work with you, see what we can work out, all right?
Okay. Again, my name is Lori. I'll reply to the email that you sent to me, Tad. Okay. And thank you both very much. God bless you, Chris. Congratulations on everything with your case, and I look forward to winning.
All right.
Yeah. Well, everybody ought to be able to. You just got to know what you're doing. You really do. If you know what you're doing, then you can really take advantage.
Okay. All right.
And like I said, it's not just with mortgages, man.
We're going to go on to our next caller. I think this is John.
Hello, brothers. This is Arizona John. It's been a long time.
Yeah, what's going on, buddy?
Well, I'm having a real severe problem because I was fighting that foreclosure. They did an illegal eviction with 15 machine guns and evicted me from my property, and they didn't have any proof of ownership, broken chain of title. They had everything wrong, and they just went ahead, which is how they do it. They bulldoze you. So right now they put a dumpster out in front of my house. I have my business records, tax records, family pictures. They're throwing everything in a dumpster. I was wondering if you got any ideas on how to make them stop.
Pay them.
Pay them what?
A UCC-1, man.
Okay, guess what?
Contact whoever thinks you owe them money.
Okay.
And tell them, look, man, I'm ready to, I owe you money, or you think I owe you money, or whatever. Okay, I'm ready to pay.
Well, I just got out of Superior Court in Pinal County, Arizona today. The judge ruled I'm in contempt of court because I filed a lease pendens lien of $10 million on my property on the mining claim, not on the house. She'd made a ruling that I can't file any UCC-1 common law lien or any lien on the property. But I already have I have a $72 million UCC-1 lien that's been recorded for years, and it's on this property. Is there a way to use the older one that's actually filed?
Yeah. Wouldn't that be grandfathered in?
Well, I've never revoked
if they're saying you can't do any more, they're not saying you can't do. You can't use the ones that you got.
Yeah, that's what I was thinking. I also have a common law lien which doesn't expire in 100 years for $72 million on the same claim, because I'm not going to go into the value. Tad knows about it, but it's a metal bearing ore deposit that's 14,000 foot thick, and over 1,000 years you could make a lot of money. So we need to live longer. But the point is, ore bodies and mine reserves are done according to the life of the mine, not how long somebody lives.
Yeah.
Thank God, right?
So these are UCC-1 liens?
One is a UCC-1. There might be more than one. I have to go. I had 4 of them.
So you get a certified copy, you call for a hearing, say, hey, I've got payment, and we have to get you Chris's case. You have to get Chris's case and find out where they said that, and I've got it somewhere. But
if you got one. Well, I don't know, though. If it's UCC-1, it probably expired after 5 years.
No, there's another method. It's a non-expiration UCC-1. That's how they're set up.
Well, that's good.
Yeah, I know
that's
about
better.
the 5 years, but they were recorded as non-expiration until the debt or amount is satisfied. So that could be a few more years yet.
Yeah.
And they were legal, notarized, and recorded. Boy, wouldn't that be a turnaround of events?
all right.
Yeah.
Well, okay,
that's what I would
that's
do.
a good idea.
Look, man.
And one quick other insert is at the court, they had a hearing on July 15th to set this court up for August 7th this morning, and I was never notified of the hearing, which I tried to bring out to the court, that me not being present at the hearing to decide when a hearing is null and void, and there's a million infractions, but of course they didn't pay attention to me.
Yeah. Yeah, they do what they want. They really do.
But I'd really like to talk to you later sometime, Chris, if that's possible.
Yeah, I don't have my other pipes here.
So get in touch with me. And I'll see what I can do to arrange a three-way. But anyway,
that's how you guys can get it done, man. I'm telling you.
Okay, John.
Well, all you gotta do is know that.
I know you got a lot to do here, so I appreciate you, and I'm glad you're doing better, Chris. God bless you guys.
Yeah, man.
Bye.
Yeah, you too, buddy.
Okay, 407 area code. If you have any questions, hit *6 and then pound on your phone, you guys. 407, go ahead.
Yeah, is that me? I guess that's me. You hear me, Chris?
That's you.
Yeah, it's AJ in Orlando. My situation is I'm under Chapter 13 because they already tried to foreclose, and I filed the bankruptcy to stop the foreclosure. Now, can I still do this even in the bankruptcy?
Yeah, man. Even if you're in a bankruptcy, man, you can do the same thing. Hold on, man. If you're claiming I owe you,
right?
Okay, I'll agree to that. I agree I owe you. Here's how you get paid.
Now, do they fill it out or I fill it out? Who fills out?
They're the ones. They're the ones that do it. If you go in there and if you owe someone money or some institution money, right. If they don't have a UCC-1 filed, they can file one.
Right.
So
Now I have there's 2 different companies, right? Because I have a first and second mortgage. So right now I'm dealing with a trustee who pays everything. I pay them and they pay the creditors. So I can't really reach these people. I have an attorney, but they don't want to hear anything about this stuff that we're talking about. They don't want to hear anything about it because that's how they make their money. That's how they eat. They don't want to hear anything about negotiable instruments or anything about fiduciaries or nothing. I told them all this stuff. I said, you guys are supposed to be helping me. You're supposed to be helping me to get out of this stuff. You guys are just going right along with everything they say. And they say, well, that's how it is. That's mortgages are like that. So how do I get to
that's how it is. You pay us to work for you, but we really work for them.
Exactly. So how do I get them to talk with the mortgage companies to do this? Because I can't talk to them. They won't even talk.
Chris, you're making a lot of noise.
Yeah, I got myself in a corner right here. Yeah, I'm trying to multitask. My wife tells me, don't do that shit, man.
I'm trying to figure out, Chris, how do I get in touch with these companies when I can't talk to them? They won't talk to me.
Yeah.
Take them to court.
All you need to do is get with if you got an attorney, I'd say fire them.
Right.
Because attorneys are scum. They're freaking scum.
They are.
That's what I'd tell them. I'd fire them. I'd get rid of them. And then start dealing, and then say, look, man, I don't have an attorney, but look, this is how this is working so far, y'all. They're learning that they can. Why do I need to hassle around and get paid $8, $9? Ask John from Arizona how long I've been dealing with him. Why do I need to do all that when I can just simply go freaking do a UCC-1? And they're starting to learn this.
Okay.
Okay.
I like that.
These mortgage companies, they're starting to learn it. And when enough of them do, there won't be any more foreclosures. Same thing with cars. You're going to cut a lot of repo men out of the freaking job because there won't be no need to do it. There'll be people buying cars straight off the lot. I don't need to go through a finance company. Hey, it's your auto dealer. Write up a contract. Do a UCC-1. They're going to learn this shit from their own friends.
It's amazing.
They're business partners, and it's just going to take time, man. I don't know if any of y'all have ever read the book Tipping Point.
Oh yeah.
That's what he's talking about. He's talking about, look, man, this is going to take a tipping point. Once that happens, once it happens, a lot of people are going to be doing this. It'll be commonplace business. As long as they don't overturn our case. This is going to be going on, folks.
Now, do you have an example of UCC-1 how to fill it out?
I do.
Yeah, well, a lot of people, you can get them from your Secretary of State. You can go, when we filed these things 9, 10 years ago, right. You went to the website, the Secretary of State's website, right. And then there's instructions that tells you how you got to fill them out, just like any tax. Anybody can do their own taxes. Right, all you got to do is read the instructions and understand them. You know?
Okay.
Then anybody can do them.
Okay.
It's the same thing. And it'll even show you, most states have got it now where if you're filling it out wrong, their AI tells you you're filling, they ostracize this field right here. You didn't fill this out right.
Oh, wow. Yeah.
They actually tell you, give you directions on it, man.
All right. Thanks, Chris. Nice to talk to you, man. It's been a year.
Yeah,
thank
buddy.
you, sir.
Have a good day.
Okay, area code 701. Your phone just unmuted.
Hi, can you hear me?
Yes, we can.
Yeah.
Oh, okay. I thought I had to press *6 or something. I filed the UCC. Okay. I filed the UCC-1. Oh, God. My God. I'm going crazy. Sorry. Hold on. Go in the other room so Jack's not upset. I filed the UCC-1 in 2023 on my mother's house because I was her 24-hour-a-day 7-day-a-week caregiver for the last about 8 years, and I have 3 siblings that thought we should split the house when she died. Also, my mom paid $30,000 down on the house, but I made all the payments out of my own pocket. So I kind of did it to protect myself for my investment. So I already have a UCC-1 filed, but my mother is deceased, and I am her personal representative on her property, and we have a case. It's a probate case number. And so I'm wondering if I can, like Chris said, get a certified copy of the UCC-1 that I have already filed, and then if I can monetize the back, and I'm not sure what exactly you mean by that. I would like an example of what you do on the back.
You ever looked at the back of a check?
Yes. You just endorse it like you endorse the back.
That's how the bank. Well, I would do it with the beneficiary signature.
Right. Okay. I know what that is. I understand the beneficiary signature. Thank you.
Yeah.
But then, can I take it to the Federal Reserve Bank pay window?
Yes, you can.
I could just do it myself? Oh,
yeah.
That would be so awesome.
Anybody that is the so-called creditor on the UCC-1 can do it.
Okay.
Anyone can do it.
Perfect. So because I'm the creditor on the UCC-1, then my son, we had a tornado here, and my son has 4 broken ribs, and he's having trouble making his mortgage. So I think I'm going to have him do one too.
Well, no, because there isn't a debt owed to him.
Oh, he has to have his bank. Oh, okay. So I can do mine.
He has to have his fiduciaries do it. You know what I'm saying? He has to go to the bank, and he has to go to the bank because he doesn't. Technically, he doesn't.
He's not the creditor.
The bank doesn't owe him. Yeah, he's not the creditor.
So on my mom's, I'm the creditor because she owed me a debt for 8 years of service and the money that I had. Okay. Yeah. I get it. Okay. That's my question.
Right. I mean, that's why you filed the UCC-1 because there was a debt that was owed to you.
Right. Yeah. So, you just took like a 600-pound weight off my back because, I've been trying to pay on my mortgage and help my son with his mortgage because he got hurt. We had a tornado here, and he was trying to help some friends set up a generator, and it was really dark, and he got hurt. So, yeah, you guys are awesome. I did email those questions into you, so you can just delete those because you already answered. Thank you so much.
All right, thank you. All right, 940 area code.
Question.
940 area code. Your phone just unmuted.
Yes. Hi. Hi, everyone. Hi, Chris.
Hey.
We spoke a few months ago, and I was dealing with a foreclosure, and they sent me a letter, supposedly, because I never received it, and I never got the chance to go to court or do anything. I was trying to do a couple of things, but they would make it really hard at the county clerk. The sheriff went in. They, basically kicked us out. I tried to fight with them. I told them to show me the paperwork. He even called the court, supposedly, and he says, no, you guys got to go. I literally lost 90% of my items. They broke it. It was just so traumatizing. I'm in Puerto Rico right now, and I know I have a 2-year, I'm in Texas, I know I have a 2-year window of doing all of this. But my question in regards to the UCC, do I have to be a secured party creditor in order to file those? Because I did file one. Okay. That's what I figured.
No, you don't have to.
Because there's so many
But you are, really. Everyone is a secured party. Everyone's a secured party creditor because they all have, everyone who has a Social Security account is. And, but you're a secured party creditor. You just don't know how much credit is due you.
Okay.
You understand?
Yes.
Everybody's a secured party creditor. But you got to know. I know I'm a secured party creditor up to a certain amount because that's what they owe me.
No.
I have a contract with the Treasury. They've agreed. They owe me. You know. And see, here's the thing with our case. If we can get the state, the appellate court, to say, okay, you guys had contracts with these people. For one, they lied, right? Tim Burchett, a freaking United States Congressman, committed aggravated perjury. Lied about it. Oh, I don't have a contract with that guy, but here, let me read the contract number to you. So that's where we're at with them. And if we can get the state of Tennessee to say, yeah, these guys are right. They don't. These people, they had contracts with these people, and they're entitled. See, the federal government's already agreed. They've already agreed that the debt is real.
Okay.
And all we got to do now is get the state to say, "Oopsie, we're sorry. You know, you guys really did have contracts, and we did you wrong." As soon as they do that, then we're looking at having the state also agreeing that the debt's valid. And then we go to the Treasury. We go to the Treasury and say, okay, these three federal agencies agree that this is real, and now the state of Tennessee is backstepping on what they claim. So we haven't committed any crimes. Where's our money? That's the ultimate goal of all this. And that's why I'm saying, y'all, do this while you can. Because, I'm in this for right rule. But if y'all can use this to your advantage and take care of a bunch of your debt, why not? Why not take advantage of it while you have the opportunity? It may not always be there.
Yeah. Okay. All right, so we're going to go on to area code 970. Go ahead. Your phone just unmuted.
Hey guys, how's it going?
Pretty good.
Good, John from New Mexico. So I like the idea of what you're saying here, Chris Hauser. So it sounds like because I've been in foreclosure off and on over the last year and a half, I've presented all the ins and outs about securitization. These courts, they don't even operate under their own rules and laws and presumptions and all this stuff. I filed a UCC-1 against the all caps name. I did a private security agreement between the all caps name and my birth name or my given name, my Christian name. They ended up going into foreclosure before it went to sale. I ended up quote reinstating the loan, even though there was nothing ever to reinstate. They never sent me any evidence. They never sent me any documentation that the loan was reinstated. They transferred the note prior to 120 days. Transferred the title prior to 120 days. So there's clouds on the title, all the stuff that goes into it. And then they reinstated the foreclosure again because I decided, well, I'm not making you guys payments because there really is no debt and you've never responded. I had prior contracts, conditional acceptances. They never responded to those. The courts just railroad us and try to convince us into believing that we're not what we claim we are. And I've even called them out and called them, that made them my fiduciary, and they still say, well, we're not your fiduciary. Well, yeah, there's stacks and stacks of evidence. I put in hundreds and hundreds of documents and evidence and case numbers, but they still blow it out of the water. So it sounds like to me, I'm back in the foreclosure process. Last week we had a hearing. They tried to pull the sovereign citizen card on me and saying that I was a sovereign citizen and that I was practicing law without a license. So at the end of the hearing, I kind of stood up and said, well,
isn't that what pro se does?
Yeah,
Think about that. Someone who goes in and argues pro se is practicing law without a license, according to what they say.
Exactly, and I even cited the different Supreme Court cases, numerous Supreme Court cases that don't exactly say it, but there's a common right, all the stuff that goes into it. I appeared in propria persona, special appearance, sui juris, and they try to convince us that, oh, you don't know what you're talking about. And it's like, no, I do know what I'm talking about, and you guys are actually willfully and knowingly being deceitful and pulling your rank, even though I challenged jurisdiction 3 times on the record. They never proved any jurisdiction. I proved through the New Mexico Supreme Court cases that they didn't have standing, and they still try to railroad us and push us through. So I finally, he says, well, any last words on the record before we end the hearing? And I said, yeah, I do by here charge you with treason. You're warring against the federal constitution, the state constitution, the people of New Mexico. Mm-hmm. You're aiding and abetting this foreign agent who has no jurisdiction and no standing. He's violating his entire oath as an attorney. And so that ended it, and I haven't heard from him since. But I get a feeling at some point it's going to come rolling back through. So I filed my UCC-1 against the all caps name. I need to file the UCC-3 statement, which transfers all the collateral and the private assets into my given name out of the other name and start a trust, is what I'm understanding through piecing this all together. But so what I'm hearing, there may be an easier way, is that if I contact this Yahoo attorney, or just bypass the attorney altogether, contact the, quote, alleged lender, who is actually really just the servicer. They never, like you said, lent any money. Contact the servicer and send them a certified agreement and another conditional acceptance, basically saying, hey, here you're saying I owe you the debt. Here's the way we can settle the debt. Put the Tennessee Supreme Court case in there, and where it's cited, where it's a UCC-1 statement is now, because they've securitized it, they don't have it as an asset in their books anymore. So can they even file a UCC-1? Because it's not even their asset. Well, it was securitized. People
that file UCC-1, they're saying that you owe them a debt. That's all UCC-1 was. It was just a public, it's like baptizing, getting baptized in water. You're doing a public confession that you're a Christian. That's all the UCC-1 is doing, is it's stating that I'm so-and-so and such owes me, X amount of dollars. That's all it is, man. Well, that's all it was. Now it's a little bit more.
Right. So because until it's overturned in the Tennessee Supreme Court, because once it's in one Supreme Court, the other states can apply that same Supreme Court ruling to their state. And so until it's overturned, then technically, per that exact Tennessee Supreme Court case with the John Lyons and et al. Plus you in there, send them a copy of that, show them where it's scripted in the notes that the UCC-1 now has value, and that you demand as trustees, because they're technically your trustee because you've given them property to hold in trust, as trustees, and it was transferred to a trust. So as trustees, I hereby instruct you as I guess not as even as beneficiary, it'd be as your executor of your estate. You're acting as your executor, not just the beneficiary. But as executor, I instruct you to file this UCC-1 financing statement per this Tennessee Supreme Court ruling in order to settle the account in full and send me my title free and clear once this is established.
Yep.
Is that kind of the route to go about doing it? Because otherwise, it's just you're still butting your head up these appeals courts that are corrupt. You're butting your head up against these Supreme Courts that are totally corrupt, and they're going to fight tooth and nail to try to hide the fraud, no matter what. So it's better to try to get it to settle, and that's what I was trying to do in the courts. But the judge even refused to even accept that he was a fiduciary. And I was like, no, I'm the executor of my estate, and you're the trustee, and you have to do what I say. I'm not a fellow trustee in which you can tell me what to do. And the more you stand on your rights, the more pissed off they get and then try to hold you in contempt of court. And it's like, well, you can't hold me in contempt of court because, one, you're not a creditor. You're operating under bankruptcy, so you can't hold me in contempt because I'm your boss. You're a public servant. And so the more you press your rights and your freedoms, the more they just lose their power.
Here's the thing too. They're not judges. They're not judges.
They're administrators.
They're administrators. They're not judges. Their pay is diminished.
And also the attorneys.
You read the Constitution. The Constitution says that if the judge's pay shall not be diminished. If they're paying taxes, then their pay is diminished. Ergo, they're not a judge.
All right.
And also, how are you going to hold me in contempt of court when you're not a judge?
Exactly.
And this isn't court.
Exactly.
This isn't court. Exactly. This is court. You wouldn't be paying taxes, dude. Right? You paying taxes there, guy? Yeah.
Yeah. Exactly. Yeah. And the attorneys. Because the attorneys are practicing law in an administrative tribunal, they're technically practicing law in an unlawful jurisdiction. And so, but the more you point out the rules, the more they say, oh, you don't know what you're talking about. It's right there in the code. It's right there in public. It's in the public record. You tell me till you're blue in the face all you want, but you're all breaking the law. And you're all in on it, and now you've just exposed yourselves because you just talk trash, and you don't even know your own laws yourself. You're not even practicing law. You're practicing private administrative policies.
Yeah.
So did Chris answer your question?
Yeah, I think so. So it sounds like at this point, rather than butting heads with these yahoos, going to the alleged lender. And sending them a conditional acceptance and say, I conditionally accept your offer based on this Tennessee Supreme Court case with John Lyons, Chris Hauser, et al. Show them the citations where it says that the UCC-1 now has value, and that I instruct you to file a UCC-1 as my fiduciary in this matter and settle the account in full and send me my title clear and clear title in full once you've accomplished your fiduciary responsibilities.
Or if they didn't file one, then you have to file one.
Because I've claimed it on my UCC-1 and I technically have a lien. Because what made me know I was in the right direction, because when they went into the foreclosure the second time, their complaint completely changed, and it said, well, he may have a security interest based on the private security agreement. He may have a security interest based on the hold harmless and indemnity contract with the all caps name. He may have a security interest. Right.
So basically, to kind of close this out, if they didn't file one, then what Chris is saying, you need to file one, and then you print out the certified copy, and then you go to the hearing and you present it to them in a hearing.
Okay.
All right, so does that answer your question?
Yes, sir. Thank you so much.
All right, thank you. Okay, so Chris?
Hey, Tad, before you cut everybody loose.
Yep.
Let me, if you guys got a pen or whatever, you want to write this case number down.
There you go.
I'll give it to you right now. Okay? It's M as in Mike, 2019-01946. That's 01946 dash Charlie Alpha, or CCA, Court of Criminal Appeals, dash R as in Romeo, 3, the number 123, R3 dash CD, like compact disc. That's the criminal appeals case, and their opinion. And then there's the Tennessee Supreme Court. I gotta scroll over here to it. The Tennessee Supreme Court case is the same number, M2019-01946-CCA-R3-CD. That's the case, and it says, let me see here. It says, in the opinion, okay, I'm looking at the opinion. It says, the Supreme Court. Oh, wait a minute. No. That was the Supreme Court case number is M9, or pardon me. It's M as in Mike, 2019-01946-SC as in Supreme Court -R11 or R1 Romeo 11 -CD. That's the Supreme Court decision, and in it says in the conclusion, if I can get over here to it right quick, we hold that the evidence in this case was sufficient to support the defendant's conviction for forgery under Tennessee Code Annotated 3914-114 B1B. We also hold that the evidence was sufficient to support the defendants for forgery in Class A felony. Accordingly, we affirm and hold the court's criminal appeals. And it says in here, that's the conclusion in the case. Although the evidence is not overwhelming, our standard of review does not require it to be. The standard of review is highly differential. It's a mere request. It merely requests us to determine whether any rational tier of fact could have found that the apparent value of the UCC-1s was at least $250,000. That's the Tennessee Supreme Court saying these things are worth money. All right? They're worth money. That's what we're looking at now. I found some coupons for Marlboros here that expired 12/31/2008.
All right, so I think that's going to do it, Chris. We've been on here for quite a while, so if you want to hang on, stay on the line. Okay, so everybody, I really appreciate you joining tonight. We had pretty good turnout, and keep an eye on your email because we'll send out some follow-ups, and I'll let you know when the site's ready. We have some kind of a course to start with, but if you're in an immediate situation, go ahead and contact me, respond to the email, and I'll do my best to see what we can do to help you. So thank you very much, everybody, and good night.
Yeah. Good night.